Let us discuss the legislations and executive orders due to civil rights movement. The civil rights movement led by the blacks resulted in bills being passed in Congress and signed by the President of United States. The legislations are as follows. First, Civil Rights Act 1964. This act prohibited discrimination based on race, color, religion, sex, and national origin in public places, public facilities, employment, and in schools. Second, Voting Rights Act 1965. This act prohibited literacy tests and poll taxes which were used to disenfranchise black voters and other minorities. Third, Fair Housing Act 1968. This act made it illegal to discriminate in the sale, rental, or financing of property. Fourth, Education Amendments Act 1972. This act prohibited discrimination based on sex in education. Fifth, Equal Employment Opportunity Act 1972. This act prohibited discrimination in hiring, promotion, termination, and compensation of its employees. Sixth, Rehabilitation Act 1973. This act prohibited discrimination in hiring, placement, and advancement of individuals based on disabilities. Thus, the various legislations removed the legal basis for discrimination. What is affirmative action? The affirmative action refers to a policy aimed to guarantee equal employment and educational opportunities for historically disadvantaged groups, minorities, and women. Affirmative action began as a government remedy to the long-standing discrimination against certain sections of the society. Apart from legislations, the executive orders by various presidents of United States shaped and expanded the affirmative action programs. Let us examine some of the executive orders. First, Executive Order or EO 1961 issued by President Kennedy. This order established the Committee on Equal Employment Opportunity and mandated that federal contractors take affirmative action to ensure that hiring and employment practices are free from racial bias. Second, Executive Order 1962 issued by President Kennedy. This order aimed to prevent discrimination in housing and related activities funded by federal money, including rental and sales practices. Third, Executive Order 1965 issued by President Johnson. This order expanded the affirmative action mandate to cover federal contractors and subcontractors, requiring them to take affirmative steps to ensure equal employment opportunities without discrimination. Fourth, Executive Order 1967 issued by President Johnson. This order amended Executive Order 1965 to include affirmative action for women. Federal contractors were required to expand employment opportunities for women and minorities. President Johnson's vision of creating a great society led to steps that changed the political, social, and economic landscape of United States. Fifth, Executive Order 1969 issued by President Nixon. This order required all federal agencies to develop and implement affirmative action programs to ensure equal employment opportunities within the federal government. Sixth, Executive Order 1970, the Department of Labor under President Nixon issued order authorizing flexible goals and timetables to correct underutilization of minorities by federal contractors. Seventh, Executive Order 1971, President Nixon revised the Executive Order of 1970 to include women. Eighth, Executive Order 1971, President Nixon administration issued memorandum permissible goals and timetables in state and local government employment practices, distinguishing between proper goals and timetables and impermissible quotas. Thus, the executive orders of various presidents of United States gave an impetus to the affirmative action programs. Challenges to affirmative action. In the late 1970s, the minority and racial quotas led to challenges and petitions related to affirmative action. In the Regents of the University of California versus Back, 1978. In this case, Alan Back, a white applicant, challenged the University of California Davis Medical School's affirmative action program, arguing that it discriminated against him on the basis of race. The U.S. Supreme Court ruled that while racial quotas were unconstitutional, race could still be a factor in admission decisions to improve diversity. Due to opposition to affirmative action in California led to passing of the California Civil Rights Initiative in 1996, which prohibited all government agencies and institutions from giving preferential treatment to individuals on the basis of their race or sex. The U.S. Supreme Court upheld the constitutionality of the California Civil Rights Initiative in 1997 by refusing to hear a challenge to its enforcement. In 1996, the Supreme Court upheld a lower court ruling that struck down the University of Texas affirmative action as unconstitutional in Hopwood versus University of Texas Law School, that there was no compelling factor to warrant the state from using race in admission decisions. In the Grutter versus Bollinger 2003 case, The US Supreme Court upheld the University of Michigan Law School's affirmative action admission policy. The court ruled that the use of race as a factor in admission decisions as part of achieving diversity was constitutionally permissible under the Equal Protection Clause of the 14th Amendment. In the Fisher versus University of Texas at Austin, Fisher 2 case, the US Supreme Court upheld the University of Texas policy, which considered race as one of the many factors in the undergraduate admission process to achieve the diversity objective. In earlier decisions, the Supreme Court had endorsed race as one of the many factors to promote educational diversity. But on 29th June 2023, the Supreme Court issued a landmark judgment in Students for Fair Admission versus Harvard and Students for Fair Admission versus University of North Carolina by rejecting affirmative action at colleges and universities around the nation, declaring that the race-based admission programs at Harvard and the University of Carolina was unlawful as it violated the 14th Amendment's Equal Protection Clause. The 6-3 ruling put a closure to a decades-long effort to diversify higher education in America on the basis of race. Leading the majority ruling, Chief Justice John Roberts, a long-time critic of affirmative action, remarked that many universities have for too long wrongly concluded that the touchstone of an individual's identity is not challenges vested, skills built, or lessons learned, but the color of their skin. This nation's constitutional history does not tolerate that choice. The study report involving several experts, which was published in the name of Shape of the River. In 1998, it was found that there was an increase in black students from a mere 0.8% in 1951 to 6.7% of the entering class in 1989. This rise was attributed to race-conscious admission policies. It was also found that most Black Americans who were admitted under affirmative action succeeded in college, had successful careers, and assumed leadership roles in their communities. Later, studies found that wherever affirmative action programs had been banned, there was a significant reduction in black students' admission rate. For example, it was observed that in the University of Michigan, where race-conscious affirmative action was outlawed, saw black students' enrollment decline to 4% in 2021 as against 7% in 2016. Similar trends were observed at the University of California, Berkeley in 2016 and 2017. Many believe that the Supreme Court ruling would have a very limited impact on existing diversity initiatives. They believe that the ruling itself has left enough room for diversity. For instance, Chief Justice John Roberts remarked, "Nothing in the opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise." Thus, while the anti-affirmative judgment will be difficult to reverse for a long time, and on the other hand, universities will be forced to change their methods of admission to their courses.